The Family Law Inquiry has just published an interim report, and it makes for interesting reading. Regarding child support, the document provides a solid foundation for future reforms. Note that no recommendations are presented at this stage, and few are even hinted at. The final report, along with recommendations, should be tabled by the last parliamentary sitting day in February 2021. If you want to lobby the inquiry to make a particular recommendation, you need to do that quickly. Let's start with the good news. It's pleasing to see that the interim report looks reasonably fair and balanced. They seem to have covered most major issues, including topics that tend to be neglected, such as the value of shared parenting, the problem of parenting orders being ignored, and the reality that parents sometimes make false claims for strategic advantage. A further positive is that the report shows different points of view. There is a submission summary and quotes from mums and dads outlining their personal experiences. We also see contributions from organisations such as the Australian Brotherhood of Fathers. Including these helps to counterbalance lobbying from the many government-funded women's groups. Just airing and presenting the different viewpoints can, hopefully, encourage better understanding and lead to less disputation. On the downside, apart from child support, it's difficult to see what big reforms are likely to come out of the inquiry. Perhaps the biggest single gripe with the family court is bias against fathers by judges and court-appointed professionals who effectively report to those judges. It's hard to see the bias problem being meaningfully addressed, though it certainly could be with appropriate legislative change. On page 4 of the report, they note that while not making any recommendations at this interim stage, the committee considers that a primary task of the committee's work is to identify measures that reduce the risk of harm to children and parents traversing the family law system. The committee also make many references to the discredited 2019 Family Law Report by the Australian Law Reform Commission. We would really like to believe the committee considers harm to include the massive damage to children who suffer from a lack of contact with their dad. Children without a close connection to their father tend to be poorer, low achievers, and experience psychological problems. For girls, there's a far greater risk that they will be sexually abused by mum's boyfriend or partner. It would also be great if the committee were looking at harm, as including the mental trauma and suicides related to fathers being marginalized in their children's lives. But this seems a little unlikely. Sadly, somehow, risk of harm in the family law industry has become synonymous with fathers potentially abusing their ex-partners, despite not living together, and even their own children. If this is the only risk area that gets priority treatment, how will biases against fathers ever be removed? We hope the recommendations will be based on a broader view. Wouldn't it be great if there was some acknowledgement that many of the fathers caught up in the family law system are good people? Many are loving parents who want nothing more than to maintain close relationships with their children. For striving to stay in their children's lives, fathers are too often maligned and demonized. Many good men end up alone, broke, depressed, and effectively having to start their lives over again. That's a big problem that should be highlighted. As Professor Edward Crook identified many years ago, the biggest losers in the family court tend to be fathers who desperately fight to see their children. They can come off as aggressive and unreasonable, and are therefore denied significant parenting time. Their profound love for their children actually works against them. One way to look at this issue is that, apart from a few abusive or overly controlling dads, the worst fathers are deadbeats who never enter the family court system. Ending up in family court is a sign that a father is at least willing to make an effort to see his kids. We would also like to see acknowledgement of the many great mothers out there who never end up in court because they agree to sensible parenting arrangements. That's a model of good parenting that divorcing mothers should normally emulate. It shouldn't be forgotten that mothers usually have the most power to resolve parenting disputes, whereas fathers can face the diabolical choice of litigating or giving up on their children. Turning to the matter of child support, the committee has mentioned a proposal for a new formula from Dr. Andrew Lancaster, and observed that many parents also support the idea that child support should be based on the 50-50 care is fair principle. We will provide a detailed update on that topic shortly. We believe that child support is an important reform area where the family law inquiry has great potential to do good for Australia's children.